CIV3701 Civil Procedure Stage 1 Part 1 Preliminary Questions. A. Cause of Action. Number 1. Introduction. Assume that you are an attorney consulting with a new client. As your client explains his problem to you, one of the first questions in your mind will be whether or not he has a valid cause of action. The answer to this question will determine whether or not you are able to proceed with the matter at all. If he does have a valid cause of action, its nature will affect the manner in which you proceed with the case. On one level, cause of action simply means the cause of the plaintiff's or applicant's complaint. But just as in a criminal matter, a crime has elements which must be alleged in the charge sheet and proved in court, so it is with a civil cause of action. It is made up of different elements which must be alleged in the papers and proved in court. In other words, cause of action simply means the elements your client will have to prove in order to be entitled to whatever relief he is seeking. Strictly speaking, these elements are determined by substantive law and fall outside the scope of civil procedure, which is a part of adjectival law. In practice, however, you will need to integrate your knowledge of substantive law with an ability to take the necessary procedural steps to obtain any relief to which your client is entitled. For this reason, we begin Part 1 of Stage 1 of the book with a brief practical overview of a few of the most common causes of action that you will encounter in practice. These causes of action will be used as examples throughout the book to illustrate the way in which various procedures work in practice. Number 2. Delictual claims. If you ask a practicing attorney to name the most common types of claims he deals with, there is a good chance that he will mention claims arising in delict. Claims arising as a result of a motor vehicle collisions and assaults are two of the most common delictual claims. Let us examine each in turn. Example 1. Motor vehicle collision. Let us take the case of a typical smash and bash. Assume that a drunken taxi driver, while on duty, disregards a red traffic light and crashes into the side of your client's car, which was being driven at the time by his wife. Assume they are married by antenuptial contract. The first point to remember is not to confuse the criminal part of this case with the civil part. The taxi driver may well be charged with a criminal offense for reckless and negligent driving, or for driving under the influence of alcohol. But the criminal case will be completely separate from any civil action your client may take to recover the cost of repairs to his vehicle. The next point to consider is whether or not your client's wife suffered any physical injuries in the collision. If she did, special rules apply. Claims for bodily injuries incurred in motor vehicle collision accidents are generally known as third-party or MVA claims. Special legislation requires you to sue the Road Accidents Fund. You may not sue the taxi driver or his employer directly for bodily injuries suffered by your client's wife. We can do no more than allude to this specialized area of law here. If the wife was not injured, the next question to ask is whether it is the client or his wife who is going to sue for the damages to the car. Do not make the mistake of thinking that it is the wife who must sue simply because she was driving the vehicle at the time of the accident. Even though it is the wife who was involved in the collision, it is clearly the husband who must sue since he suffered the damage because the car belongs to him. But who is your client going to sue? The drunken taxi driver was to blame for the collision, and your client is certainly entitled to sue him. But what if the taxi driver was employed by a company which owns the taxi? May your client also sue the company? The answer is that your client may indeed be entitled to sue the company for damage to the car, not because it owns the taxi, but because the taxi driver was acting within the course and scope of his employment when the collision occurred. This is also known as vicarious liability. So in this case, where there would be two defendants to the action. Both would be liable to pay your client's claim. but as soon as one of them does so, the other is absolved from having to make payment. You will recall from your study of substantive law that damages for patrimonial loss, as in this case, are always recovered under the lex aquilia. The main elements of your client's cause of action against the taxi driver would be the following. First, a wrongful act. This is an unlawful act which causes someone prejudice. Unless you are a police officer forcing a fugitive's vehicle off the road, it is difficult to think of a situation in which crashing into someone else's vehicle would not be classified as a wrongful act. One way of making this allegation would be to state that on or about a certain date, at or near a certain place, a collision occurred between motor vehicle details of the plaintiff's vehicle owned by the plaintiff and motor vehicle details of taxi driven by the defendant. Note the use of the phrases in or about and at or near, which prevents nitpicking by the defendant. Secondly, fault in the form of negligence. It is necessary to show fault, either in the form of intention or negligence. The fact that the taxi driver disregarded a red traffic light clearly indicates that he was negligent. One way of making this allegation would be to state that the taxi driver was at fault in that he was negligent in one or more or all of the following respects. You would then make a series of allegations relating to the taxi driver's alleged negligence, being careful to join these allegations in with the term and/or, and stating from the most particular, for example, the first defendant disregarded a red traffic light and collided with the plaintiff's vehicle, and ending with the most general. For example, the first defendant failed to avoid a collision when, by the exercise of reasonable care, he could have done so. Note that an allegation that a defendant has committed a criminal offense, for example, he drove over the speed limit, does not necessarily mean that he was negligent. Instead of alleging that the defendant drove over the speed limit, you should rather allege, for example, that he drove at a speed that was excessive in the circumstances. By making these allegations, you will be alleging that the taxi driver was 100% at fault. Note, however, that fault is not an all-or-nothing game. Frequently, the defendant alleges that he was not the only one who was at fault, alleging that the plaintiff also did something negligent which contributed to the accident. If the court concludes that both parties were negligent, damages are apportioned by the court between the parties based on each party's respective negligence. This is known as contributory negligence. Thirdly, causation. There needs to be a connection or a causal link between each element of the cause of action. The fact that the taxi driver drove through a red traffic light was clearly the sole cause of the collision. This, in turn, caused the damage to your client's vehicle. The wording of the particulars of the claim should refer clearly to this link. Number 4. Damages. Since the action is for patrimonial loss, that is, loss to one's patrimony or estate, it is necessary for the plaintiff to show that some loss was suffered. Neetling et al. Pointed out that the owner of property is entitled to damages which are theoretically calculated on the basis of the reduction in market value of such property at the time of the inflicting of damage. In order to prove market value, a plaintiff is required to demonstrate the original value of the property and the decline in value which has taken place up to the time of the damage-causing event. Damage to a motor vehicle is usually quantified in the following rather complex way, and usually by an assessor or quantifier who would be called as an expert witness. First of all, the pre-collision value of the motor is determined by consulting the Auto Dealer's Digest, which provides both retail and trade-in values for different makes and models of motor vehicles. The market value is taken to be the average between the trade-in value and the retail value for the vehicle in question. The post-collision value of the vehicle is then determined by asking a asking 3 qualified and reputable panel beaters to assess the value of the damaged motor vehicle. The post-collision value is taken to be the highest of the 3 assessments. The difference between the pre- and post-collision values of the vehicle is then calculated by subtracting the post-collision value from the pre-collision value. The fair and reasonable cost of repair is also calculated by asking each of the 3 qualified and reputable panel beaters referred to above to provide a quotation for repairing the vehicle. The lowest of the 3 quotations is taken to be the fair and reasonable cost of repair. Finally, the fair and reasonable cost of repair is compared to the difference between the pre- and post-collision values of the vehicle. The lower of these 2 figures is the quantum of the damages that are claimed from the defendants. As a final point, note that a claim for damages is undetermined or unliquidated. In other words, the precise amount of the damages will remain uncertain until the court delivers its judgment, stipulating the exact amount to be paid to the person who has suffered the damage. Once the court gives its judgment, the claim becomes determined or liquidated. Fifth, vicarious liability. A further element would, of course, be required to complete your client's cause of action against the owner of the vehicle, namely the company. The fact that the taxi driver was acting within the course and scope of his employment when the accident happened, that is, he was not off on a frolic of his own, to visit a friend, for instance, at the time, would have to be alleged. Notice that all the elements above are linked to arose at the place where the collision occurred. This is different from certain other cases where the various elements of a particular cause of action may arise in different places. Identifying the place or places where the different elements of a cause of action arise is important when it comes to deciding which court has jurisdiction to hear a particular matter. This will be discussed in detail later in the section dealing with jurisdiction. At this stage, note that it is essential to allege both jurisdiction as well as locus standi in every claim that you bring. Example 2. Assault. Assume that a bouncer at a nightclub punches your client's 16-year-old son on the nose. The son has to have an operation to straighten his broken nose, which is badly scarred, and is unable to take part in 2 school rugby matches. Once again, do not confuse the criminal side of this matter, possibly a criminal charge of assault with intent to do grievous bodily harm against the bouncer, with a civil case by your client and his son to recover damages. Be careful when deciding who is going to sue in this case. Both your client and his son have been adversely affected by the assault. The son has suffered bodily injuries and the father has, presumably, paid the medical bills. Therefore, both father and son will sue in this case. But there is another problem. The son is a minor. Generally speaking, the terms of minor and child mean the same thing, that is, a person under 18 years old, and will not be able to sue unless he is duly assisted or duly represented by his father. When deciding who is going to be sued, the bouncer is the first obvious target since he caused the son's injuries. Of course, the owner of the nightclub may also be sued on the basis of vicarious liability if the bouncer was acting within the course and scope of his employment at the time of the assault. The main elements of your client's cause of action against the bouncer would be the following. First, a wrongful act. The main issue here will clearly be whether or not the bouncer has any defense, for example, that he was acting in private defense when he punched your client's son on the nose. If he was, his act was not wrongful and your client will not have a valid cause of action, although of course you may want to bring the action anyway and dispute the bouncer's version that he was acting in self-defense. Secondly, fault in the form of intention. It must be alleged that the bouncer intended to punch your client's son. Third, causation. It must be alleged that the punch broke the boy's nose. Fourth, damages. Where damages are claimed for bodily injuries, it is important to break the claim down into its various components, such as medical expenses, pain and suffering, loss of past and future income, loss of amenities of life, such as being unable to play in a rugby match, and disfigurement. Note, once again, that a damage claim for bodily injuries is unliquidated until the court delivers its judgment quantifying the damages. Fifth, vicarious liability. The action against the bouncer's employer would also require your client to allege that the bouncer was acting within the course and scope of his employment at the time of the assault. Number 3. Contractual claims. Claims based on contract are very common in practice. One of the most common types of contract is a contract of purchase and sale. Let's look at some simple examples, first from the seller's perspective and then from the buyer's perspective. Example 1. Sale on credit. The seller's remedies. Your client agrees to sell her second-hand skedonk, a 10-year-old bakkie with 190,000 kilometers on the clock, to a student for 20,000 rand. When the student arrives to pick up the bakkie, he gives your client 1,000 rand and promises to pay the balance within 1 week. Your client agrees to this arrangement. Your client explains to the student that it is important that the outstanding balance be paid on time because your client intends to use the money as a down payment on another vehicle, which she needs to get to work and back. Your client gives the bakkie to the student and waits for 1 week for the student to pay her the 19,000 owed. Despite numerous requests by your client, the student never pays the outstanding balance of 19,000 rand. To complicate matters further, the student crashes the bakkie, causing approximately 2,000 rand damages to the front bumper. Because your client agreed to accept payment of the balance of the purchase price 1 week after the date of delivery of the bakkie, it may be assumed that this sale was a sale on credit. The significance of this is that ownership of the bakkie would have passed to the student on the day he took the bakkie. This affects the remedies available to your client. Your client has 2 options open to her. Option 1. She may try to enforce the contract by demanding that the student pay her the outstanding balance of the purchase price, that is, the 19,000 rand. This is a claim for specific performance in terms of the contract. Or alternatively, option 2, she may cancel the contract and try to get the bakkie back. This is a claim for cancellation of the contract together with restitution. If your client opts for option 1, that is a claim for specific performance, she may also ask for the damages. Because the student did not pay her, your client was unable to put a down payment on another vehicle. Let's assume that because of this, she was forced to travel to work in a taxi for 2 weeks. To keep it simple, let's assume further that the cost of hiring a taxi is double the cost of your client using her own vehicle. Your client would then be entitled to claim half of the cost of hiring the taxi, that is, damages, in addition to payment in the amount of 19,000 rand, that is, the specific performance in terms of the contract. If your client chooses option 2, it is clear that simply returning the vehicle to her will not put her in the same position she was in before the contract was entered into. The vehicle has been damaged and is not in the same condition it was at the time of the sale. Therefore, in addition to restitution, that is, the return of the vehicle, your client will also be entitled to claim damages, that is, 2,000 rand being the fair and reasonable cost of repairing the front bumper. Furthermore, your client's damages will not be restricted to recovering the fair and reasonable cost of repairs to the bumper. She will also be able to recover half of the cost of taxi hire as explained in the previous paragraph. Your client will not be entitled to set off this amount of 1,000 rand against the 2,000 rand damages to be paid by the student. This is because the amount of 2,000 rand is an unliquidated amount. Only once the court gives a judgment to the effect that the damages to the bakkie amounted to 2,000 rand does this amount becomes a liquidated amount. Only at this stage, that is, after judgment, can the amount of 1,000 rand be set off against the amount of 2,000 rand. Whichever option she chooses, your client will have to allege and prove that there was a valid contract of sale. This involves proving the following. First, that there was an agreement to buy and sell the bakkie. Secondly, that there was an agreement on the item to be bought and sold, that is, the bakkie. And lastly, there was an agreement on the purchase price to be paid, that is, 20,000 Rand. If your client decides to claim specific performance, she will have to prove not only the contract, but also that the purchase price is due and payable because she has delivered the bakkie to the student in accordance with the contract. In other words, your client is making the following plea to the court that there was a valid contract, I've performed my part of the contract, I want the court to order the student to perform his part. If your client decides to cancel the contract, she will have to prove not only the contract, but also that the student breached the contract, that is, by not paying the purchase price, and that she has the right to cancel the contract because the breach was material. That was, a refusal to pay the purchase price is certainly material. A notice of cancellation of the contract prior to the legal proceedings is not strictly necessary, since the legal documents initiating the action will serve this purpose. In either case, if damages are to be claimed, they will have to be proved. Example 2. Sale for cash. The seller's remedies. Let us take the same facts as set out in the previous example. But let us assume that when your client let the student take the bakkie, she made it clear that ownership would not pass until the full amount of the purchase price had been paid to her. In this case, the sale is not for cash and ownership of the bakkie remains with your client. Your client would have the same remedies open to her as set out in the previous example. In addition to these remedies, however, she might have a further option open to her if she wanted to recover the vehicle. An owner is entitled to reclaim possession of his or her property by making use of the re vindicatio, that is, vindicatory action. In terms of the re vindicatio, all that your client would have to prove in order to get her bakkie back would be the following. First, that she is the owner of the bakkie, and secondly, that the defendant was in possession of the bakkie at the time of the institution of the action. If your client decided to take this route, she would also want to claim the 2,000 Rand for the damage to the front bumper. This would be a delictual claim. Your client would need to return the 1,000 Rand paid to her, or else she will have been unjustly enriched. Apart from the above, it would be wise for your client to claim alternative relief in case the student disposes of the bakkie while the litigation is in progress. The alternative relief would be claimed in terms of the actio ad exhibendum and would be for payment of the value of the bakkie from the erstwhile possessor. In terms of the actio ad exhibendum, your client would have to prove the following. First, that she was the owner of the bakkie when it was disposed of by the student. And secondly, the student had been in possession of the bakkie. Thirdly, at the time the student disposed of the bakkie, he knew that it was owned by your client. That is, the student's loss of possession was malafide. And fourthly, the student intentionally disposed of the bakkie. Okay, and now for example 3, the buyer's remedies. Let us take the same facts as set out in the previous 2 examples, but assume that the student pays the seller in full. After driving the bakkie for a day, the brakes fail, and the bakkie crashes into the student's surfboard, which is stored in the garage. Damages of 2,000 Rand are caused to the front bumper of the bakkie and the surfboard, with 1,000 Rand is completely destroyed. The first point to note is that the defect to the vehicle seemed to have been latent, that is, hidden, rather than patent, that is, obvious. If it had been a patent defect, the student would have had no remedy in this case, because he should have seen the defect when he bought the vehicle. The next question is to ask is whether or not the seller or the buyer knew about the defect. First, let's assume that the seller knew that the brakes were defective. That, for example, they were being held together with a piece of wire, and deliberately withheld that information from the student buyer. In this case, the student could do either of the following. First, he could stick to the contract and claim the benefit of his bargain, that is, full repairs to the bakkie as well as damages, the cost of replacing his surfboard. And secondly, he could cancel the contract, return the vehicle, and claim his money back, as well as damages, that is, the cost of replacing his surfboard. Now, let us assume that neither the seller nor the student buyer was aware of the latent defect to the brakes of the vehicle. In such a case, you would have to ascertain first whether or not the vehicle had been sold footstewards, that is, as is. If so, the student buyer would have no remedies at all under the common law, although he may have a remedy if the Consumer Protection Act were to apply to the transaction. If there was no footstewards clause, the student buyer would be entitled to one of two remedies. First, the actio redhibitoria, which allows the contract to be brought to an end, would be applicable if the latent defect was such that it rendered the vehicle completely unfit for its purpose, which is probably not the case here. Or secondly, the actio quanti minoris, which allows a reduction in the purchase price, would be applicable if the latent defect was not such as to render the bakkie unfit for its purpose, which seems to fit the facts in this case. As far as the first claim is concerned, the student would have to offer to return the bakkie to the seller in return for a full refund of the purchase price, plus any reasonable expenses incurred in relation to the vehicle. The student would not be entitled to claim for the damage to his surfboard. As far as the second claim is concerned, the student would only be able to claim a reduction in the purchase price of the vehicle. The court would look at what the vehicle was worth with its defective brakes, and if this was less than what the student paid for it, would award the difference between what the student paid and what the vehicle was worth. Number 4. Divorce actions. Example 1. Divorce. Divorce actions are common in practice and are procedurally different from other types of actions in at least 3 ways. First, special rules apply to jurisdiction in these cases. Secondly, the courts demand that the legal documents initiating action in these matters be served in a certain way, that is, by means of personal service only. And lastly, it is possible to apply for a special type of interim relief while the divorce action is still pending, that is, interim care of or contact with the children. With divorce matters, there are usually several claims, each constituting a separate cause of action. Of course, the most important claim will relate to the divorce itself, namely that the marriage has irretrievably broken down, but usually there are further claims related to the future maintenance of the plaintiff or defendant's spouse, and or the division of the estate, and or the forfeiture of the benefits of the marriage, and or the sharing of pension benefits, and or the redistribution of the assets of the marriage, and or the future care, maintenance, and guardianship of the couple's children. In very general terms, a person claiming a divorce must satisfy the court of the following. First, that there was a valid marriage between the parties which still exists. Secondly, the court has jurisdiction. Third, the marital regime under which the parties are married, for example, are they married in community of property or by antenuptial contract with or without accrual. Fourthly, whether or not there are children under the age of 18 or children who are still dependent on the parties, and if so, that satisfactory provisions have been made to ensure the welfare of such children. Fifth, whether or not the person suing for divorce wants to claim sole guardianship, the right to care for or maintain contact with any children, in which case allegations must be made in support of this claim. Number 6. the amount of maintenance required for the children. 7th, that the regulations promulgated in terms of the Mediation in Certain Divorce Matters Act 24 of 1987 have been complied with. 8th, the grounds upon which the divorce is being sought. The most common ground is that the marriage has irretrievably broken down. In other words, the marriage relationship has reached such a state of disintegration that there is no reasonable prospect of a normal marriage relationship being restored. 9th, whether maintenance is being claimed by the person seeking the divorce, or whether the person seeking the divorce is offering to pay maintenance to the defendant. And number 10, whether or not the parties have drawn up a settlement agreement before the proceedings started. The basic purpose of a settlement agreement is to divide up the property between the spouses, although in practice settlement agreements frequently also record the parties' agreement as to their rights and obligations in respect of minor children. And then, the following proprietary claims may be encountered. First, the parties have jointly owned assets. For example, they are married in community of property. Then a division of the joint estate will be claimed. Secondly, specific performance of any outstanding obligation created by an antenuptial contract. Third, redistribution of assets in terms of subsection 7(3) to 6 of the Divorce Act. These subsections basically deal with marriages out of community of property, which were entered into before the new accrual system became the norm. In some such instances, hardship could result if, during the marriage, one party contributed directly or indirectly to the maintenance or increase in the estate of the other party, and was told at the end of the marriage that he or she was entitled to nothing. Section 7, subsection 3 allows the court to order that assets be transferred from one spouse to the other. Fourth, forfeiture of patrimonial benefits in terms of Section 9 of the Divorce Act 70 of 1979. When a decree of divorce is granted, the court may make an order that the patrimonial benefits of the marriage be forfeited by one party in favor of the other, either wholly or in parts, if the court, having regard to the duration of the marriage, the circumstances which gave rise to the breakdown thereof, and any substantial misconduct on the part of either of the parties, is satisfied that the one party, in relation to the other, will be unduly benefited if the other, or if the order for forfeiture is not made. CIV3701, Stage 1, Part 1b, Locus Standi. Number 1. Introduction. A person who has a right to sue or be sued in a particular matter is said to possess locus standi, in judicio, that is, legal standing, in that matter. There are two tests to determine the locus standi of a party. Firstly, whether or not the party concerned has a direct and substantial interest in the matter, and secondly, whether or not that party has legal capacity to litigate in the matter. To illustrate the need for these two tests, let us examine two simple problems. Problem 1. Assume you are a candidate attorney who cannot wait to get some hands-on legal experience. A friend tells you that her car was damaged in an accident some time ago, but that she decided to pay for the damage herself instead of getting involved in a legal dispute. You try to convince her to reconsider her decision, but she refuses. You then decide that you will sue the other party on your friend's behalf. Do you think that you should be allowed to do so? Or problem number 2. You are a famous attorney. One day, you are sitting in your office when a young child walks in and tells you that he wants to sue his father for failure to pay his pocket money. You tell the child to wait outside while you think about the case. When a man walks into your office with a fried egg on his head and 2 Vienna sausages behind his ears, he tells you that he is an alien and wants to sue the President of South Africa. Do you think that these two people should be entitled to litigate? The first problem deals with whether or not a potential litigant has a direct and substantial interest in the proposed litigation. The second problem deals with whether or not a potential litigant has the necessary capacity to litigate. Let's look at each of these issues in turn. B. Locus standi. Number 2. Direct and substantial interest. 2.1. The common law position. A person wishing to institute or defend legal proceedings must have a direct and substantial interest in the right that is the subject matter of the litigation, and in the outcome of the litigation. In other words, you cannot take over someone else's legal battle simply because you wish to litigate for the fun of it, or for some other reason. Your legal standing should be determined first. Legal standing is concerned with whether or not the particular litigants in a matter are entitled to prosecute or defend the matter in court. The issue of standing is divorced from the substance of the case and arises as a point in limine at the outset, before the merits are considered. Furthermore, a financial interest alone is not sufficient. Jones and Buckle sum up the requirements for a direct and substantial interest as follows. A. The plaintiff or applicant for relief must have an adequate interest in the subject matter of the litigation, which is not a technical concept but is usually described as a direct interest of the relief sought. B. The interest must not be too far removed. C. The interest must be actual, not abstract or academic. And D. The interest must be a current interest and not a hypothetical one. Sometimes, in practice, it can be difficult to decide whether or not your client has a direct and substantial interest in a matter. For example, assume that your client owns just one share in a massive publicly owned company. This would probably not be sufficient to give him locus standi to sue on behalf of the company. Your client's ownership of the share would be regarded as an indirect financial interest, as opposed to the direct and substantial interest required. Note, however, that a person, for example, a shareholder or director, can initiate a court action on behalf of a company in order to protect the company's legal interests. This is because of a special provision in the Companies Act that allows for such actions. As you can see, the South African common law relating to this issue is complex and detailed. You would be well advised to consult specialist texts as well as the relevant cases when dealing with particular matters in practice. 2.2. Actions based on the Bill of Rights. While the above common law position is the general rule, it is important to bear in mind that in respect of actions based on the Bill of Rights, the provisions of the Constitution have extended and broadened locus standi to persons and groups who, in the past, would not have been considered to have a direct and substantial interest in a matter. In terms of Section 38 of the Constitution, which is often referred to by practitioners as the standing clause, that is, the clause which determines whether or not someone has legal standing, or locus standi if you prefer, in a matter, relief may be sought by A. Anyone acting in their own interest. B. Anyone acting on behalf of another person who cannot act in their own name. C. Anyone acting as a member of or in the interest of a group or a class of persons. D. Anyone acting in the public interest. And E. An association acting in the interest of its members. Although each of the above-mentioned subsections of the subsection 38 is worthy of further comment, in a book of this kind we only have space to touch briefly on one or two. 2.2.1 Class actions under Section 38C of the Constitution. Section 38C, which allows for so-called class actions, is worthy of particular focus and has been the subject of much judicial attention. While the class actions have always been enshrined in Section 38C, nothing was done to regulate the bringing of class actions, and the courts have had to regulate the bringing of such actions by using court-made rules. In the Unisa case in the Supreme Court of Appeal, Cameron pointed out the value of such actions in a country such as South Africa. The class action was until 1994 unknown to our law, where the individual litigant's personal and direct interest in litigation defined the boundaries of the court's powers in it. If a claimant wished to participate in existing court proceedings, he or she had to become formally associated with them by compliance with the formalities of joinder. The class action cuts through these complexities. The issue between the members of the class and the defendant is tried once. The judgment binds all and the benefits of its ruling accrue to all. The procedure has particular utility where large groups of plaintiffs each has a small claim that may be difficult or impossible to pursue individually. The reason the procedure is invoked so frequently lies in the complexity of modern social structures and the attendant cost of legal proceedings. In order to bring a class action, the group must first be certified as a class by a court. In Mukadam versus Pioneer Foods Proprietary Limited and others, the Constitutional Court explained the reasons for requiring certification. Courts must embrace class actions as one of the tools available to litigants for placing disputes before them. However, it is appropriate that the courts should retain control over class actions. Permitting a class action in some cases may, as the Supreme Court of Appeal has observed in this case, be oppressive and as a result inconsistent with the interests of justice. It is therefore necessary for courts to be able to keep out of the justice system class actions which hinder instead of advancing the interests of justice. In this way, prior certification will serve as an instrument of justice rather than a barrier to it. The Gauteng Local Division, Johannesburg, in a precedent-setting judgment, certified a class representing tens of thousands of present and former mine workers who intend to bring an action for damages against gold mining companies for exposure to dust that is alleged to have caused silicosis and tuberculosis. As the law in this area is quickly developing, and class actions will be of increasing importance in the future, we recommend that you consult specialist text dealing with the topic. 2.2.2 Own interest standing in terms of Section 38A of the Constitution. As to the issue of standing under Section 38A, Chaskelson, as he then was, stated as follows in the constitutional case of Ferreira versus Levin N.O. Whilst it is important that this court should not be required to deal with abstract or hypothetical issues and should devote its scarce resources to issues that are properly before it, I can see no good reason for adopting a narrow approach to the issue of standing in constitutional cases. On the contrary, it is my view that we should rather adopt a broad approach to standing. This would be consistent with the mandate given to this court to uphold the Constitution and would serve to ensure that constitutional rights enjoy the full measure of protection to which they are entitled. Key to establishing constitutional own interest standing is that a litigant must show that his or her rights or interests are directly affected by the challenged law or conduct. The Constitutional Court summarized the factors to establish own interest in standing under the Constitution as follows. First, a litigant need not show the same sufficient personal and direct interest that the common law requires, but must still show that a contested law or decision directly affects his or her rights or interests, or potential rights or interests. Secondly, this requirement must be generously and broadly interpreted to accord with constitutional goals. Third, the interest must be real and not hypothetical or academic. Fourth, a purely financial self-interest may not be enough. In such a case, the interests of justice must also favor affording standing. Fifth, standing is not a technical or strictly defined concept, and there is no magical formula for conferring it. It is a tool a court employs to determine whether a litigant is entitled to claim its time and to put the opposing litigant to trouble. Number 6. Each case depends on its own facts. There can be no general rule conferring all cases. In each case, an applicant must show that he or she has the necessary interest in an infringement or a threatened infringement. Seventh, a measure of pragmatism is called for in determining standing. The facts of the case of giant concerts illustrate the potential difficulties of establishing own interest standing. The applicant, Giant Concerts CC, or Giant, sought to challenge the lawfulness of a sale of land by the eThekwini municipality to the respondent. Giant objected to the sale and indicated that any offer made to purchase the property would be greater than the offer that had been made by the respondent. But Giant refused to disclose its exact proposal or to provide an exact figure that it would be prepared to pay. Giant relied on constitutional own interest standing based on its right to just administrative action, and it asserted a commercial interest in the property. The Constitutional Court held that Giant had failed to establish its locus standi because it failed to substantiate its purported interest in that it failed to produce a plan, price, or proposal in respect of the property. The Giant Concerts case illustrates the importance of establishing in the papers and pleadings the nature of the interest relied on. Practitioners must also select the correct ground in Section 38 of the Constitution on which to rely in bringing proceedings. If you are acting in the public interest, do not rely on own interest standing, and vice versa, or the court may well conclude that you do not have locus standi and may refuse to hear you. This is known as being non-suited. Note, however, that you are not confined to rely on one ground of standing in Section 38, but remember to substantiate each ground on which you rely. 3. Capacity to litigate. As a general rule, both natural persons and corporate persons, such as companies and close corporations, possess the capacity to sue and to be sued. There are, however, exceptions to this general rule. Some persons cannot sue or be sued unless they are represented by or assisted by someone else. A child, for example, must be represented or assisted by his guardian. Other persons, such as those who choose to reside in enemy territory during a war, are prohibited from instituting action in our courts, but may have action taken against them. Yet others, such as diplomats, are free to institute legal action in our courts, but are protected by diplomatic immunity from having legal action taken against them. Let us examine the various exceptions to the general rule in turn, starting with the most common. 3.1. Children. A child does not have locus standi and must be either duly assisted by or secondly represented by, thirdly, his guardian. The difference between duly assisted by and represented by may be illustrated by the two distinct ways in which the child and his guardian will be referred to or cited in legal documents, depending upon whether the child is duly assisted by or represented by the guardian. A child who is acting in his own capacity, duly assisted by his guardian, may be cited as follows in the document initiating the legal proceedings. The plaintiff, John Smith, a male preschool student who resides at 123 North Street, Durban, and who is duly assisted hereby by his father and natural guardian, Peter Smith, an adult male plumber who resides at 123 North Street, Durban. And secondly, a child who is represented by his guardian may be cited as follows. The plaintiff is Peter Smith, an adult male plumber who resides at 123 North Street, Durban, and who is cited in his representative capacity as father and natural guardian of John Smith, a male preschool child who resides with his father at 123 North Street, Durban. Forgive me. 3.1.1. What is a child? In terms of Section 17 of the Children's Act 38 of 2005, a natural person attains majority at the age of 18 years. A natural person under the age of 18 years is defined as a child, and must therefore be duly assisted or represented by his guardian in civil litigation. In most cases, a child's guardians will be both his biological mother and his biological father. In terms of Section 18, Subsection 4, read with Section 18, Subsection 3b of the Children's Act, each of a child's guardians is competent to assist or represent that child in legal matters, subject to any other law or any other of a competent court. 3.1.2. Children under the age of 7. A child under the age of 7 must be represented by, rather than assisted by, his guardian in civil litigation. In other words, actions and applications are brought and defended in the name of the guardian, who acts in a representative capacity on behalf of the child. 3.1.3. Children of 7 years and older. With a child who is 7 or older, you have a choice whether to institute the action in the name of the guardian in his representative capacity or in the name of the child duly assisted by the guardian. 3.1.4. Costs. Whether the guardian duly assists the child or represents the child is the litigant in both instances. Unless the guardian institutes an action recklessly or frivolously, he is not liable for any costs awarded against the child, or for payment of any damages which the child may be ordered to pay. 3.1.5. Dual capacity. An interesting situation arises when a guardian is involved in a matter both on his own behalf and as a representative of his child. In Latin legalese, you would say that he is involved eu nomine, that is, on his own behalf, and nomine officio, in representative capacity. Typically, this type of situation arises where a child has suffered injuries in an accident caused by the negligence of another party. Usually, both the child and the guardian suffer damages as a result of the child's injury. The guardian might have to pay for his child's medical expenses and may take time off work to go to the hospital, thereby forfeiting a day's wages. The child may not have to pay any bills arising out of the accident, but will often be able to claim for pain and suffering, loss of amenities of life, loss of future income, and etc. In such a case, you must distinguish carefully between those claims for which the guardian is suing on his own behalf and those claims for which he is suing as a representative of his child. Your citation, that is, the description of the parties in the pleadings, would look a little something like this. The plaintiff is John Smith, an adult male advocate who resides at 123 North Street, Durban, who sues herein in his personal capacity as well as in his representative capacity as father and natural guardian of Sarah Smith, a female preschool child who resides with her father at 123 North Street, Durban. 3.1.6. Appointment of a curator ad litem. In cases where, first, a child has no guardian, secondly, the guardian refuses to act on the child's behalf, Thirdly, the guardian of a child cannot be found, or lastly, there is a conflict of interest between the child and the guardian. You must make an application to court to appoint what is called a curator ad litem to act on the child's behalf during the legal proceedings. Usually, you will make this application before proceedings are instituted. If you have not done so, however, you may apply to court to appoint a curator ad litem after proceedings have commenced, provided it is to the child's benefit, and the court would probably have approved the application had it been made at the proper time. Once the curator ad litem has been appointed, the child may be cited as follows. The plaintiff is John Smith, a male preschool child who resides at 123 North Street, Durban, duly assisted by Peter Nkobu, an adult male advocate who resides at 345 South Street, Durban, in his capacity as curator ad litem. 3.1.7 Litigation without assistance. A child may litigate unassisted by his guardian or a curator ad litem in the following instances. First, when applying for the appointment of a curator ad litem. Secondly, if the court grants him permission to sue unassisted. Third, when applying for permission to marry without a parent's or guardian's consent. And lastly, when the proceedings are permitted by statute. 3.1.8 The Children's Act and Bill of Rights. It is important to note that the Children's Act extends locus standi in certain matters to a significant extent. In terms of Section 15 of the Children's Act, any person listed below has the right to approach a competent court, alleging that a right in the Bill of Rights or in the Children's Act has been infringed or threatened. A child who is affected by or involved in the matter to be adjudicated. B. Anyone acting in the interests of the children or on behalf of another person who cannot act in their own name. Or C. Anyone acting as a member of or in the interests of a group or class of persons. And D. Anyone acting in the public interest. Section 14 of the Children's Act provides that every child has the right to bring and to be assisted in bringing a matter to court. Section 28, subsection 1H of the Constitution provides that every child has the right to a legal practitioner assigned to the child by the state, and at the state's expense in civil proceedings affecting the child if substantial injustice would otherwise result. The Durban and Coast Local Division, as it was then, has held that a child may apply directly to the Legal Aid Board for a legal representative to be appointed to him or her, as the Legal Aid Board has the power in terms of the Legal Aid Act to render legal assistance to a minor. In discharge of the state's obligation in terms of Section 28, subsection 1H of the Constitution, the Legal Aid Board is not constrained by a need to obtain either the consent of the child's guardian or that of any person exercising parental responsibilities and rights in relation to the child. Wallace, as he was then, concluded that this was necessary for the child's voice to be heard. Note that the law relating to children is complex and detailed. In a book of this kind, it is not possible to summarize this area of law comprehensively. You would be well advised, therefore, to consult the relevant legislation, case law, and specialist texts before dealing with matters involving children. 3.2 Married Women. 3.2.1 Abolition of the Marital Power. The last vestiges of the marital power which gave husbands certain legal rights and responsibilities in respect of their wives were abolished on the 1st of December 1993. Before this date, the issue of locus standi in relation to married women was a complex one. Women who were married before the Matrimonial Property Act 88 of 1984 came into effect and who did not specifically enter into an antenuptial contract to exclude the marital power were, by operation of law, married in community of property and subject to the marital power of their husbands. Thus, they did not have locus standi to sue or be sued without the assistance of their husbands. The Matrimonial Property Act 88 of 1984 abolished the marital power for those marriages entered into after the Act came into operation. So, in general terms, wives married after the 1984 Act were freed from the marital power, but many wives who were married before the 1984 Act were still subject to the marital power. On the 1st of December 1993, the entire issue became much less complicated when the Matrimonial Property Act was amended so as to abolish the marital power in respect of all marriages, including those entered into before the Matrimonial Property Act 88 of 1984 came into operation. All married women now possess locus standi. A remnant of the sexist past remained for a number of years in the High Court Rules 17, Subsection 4, requires the marital status of a female plaintiff or defendant to be stated in a summons. As mentioned earlier in this book, however, the High Court in the case of Netcor Bank Limited versus Henop and another found that the reference to the defendant's sex and women's marital status as required by the rule is outmoded and anachronistic. It also offends the equality provisions contained in the Constitution, inasmuch as the preamble speaks of equality between men and women, and Section 9, Subsection 1 provides that every person shall have the right to equality before the law. And Section 9, Subsection 3 is emphatic that no person shall be unfairly discriminated against, directly or indirectly, on the grounds of sex, gender, or disability. Accordingly, the court found that in these enlightened times, the omission to the state's defendant's sex and, in the case of a woman, her marital status in the summons is of no consequence and certainly not amenable to render the plaintiff's application for summary judgment to be fatally defective. The rule was amended in 2014 to remove any reference to the marital status of women, although Rule 17 still requires the plaintiff's gender to be stated. 3.2.2 Consent to litigate. Marriages in community of property. Although the problems with regard to the locus standi of married women were solved by the amendment to the Matrimonial Property Act on the 1st of December 1993, there is another aspect that you have to bear in mind when dealing with actions by persons who are married in community of property. In terms of Section 17, Subsection 1 of the Matrimonial Property Act, a spouse who is married in community of property, whether husband or wife, may not institute or defend legal proceedings against another person without the written consent of the other spouse. Such written consent is not required, however, in respect of legal proceedings. First, between spouses. Secondly, in respect of a spouse's separate property. Third, for the recovery of damages other than damages for patrimonial loss, by reason of the commission of a delict against them. For example, in a motor collision case, a spouse may have a claim for damage to the car, which is patrimonial loss, as well as a claim for pain and suffering, which is not a patrimonial loss. The spouse would need written consent from his wife to commence action to recover the cost of repairing the damage to the car, but not to commence action to claim for his pain and suffering. And lastly, in respect of a matter relating to his profession, trade, or business. Note that Section 17 of the Matrimonial Property Act does not relate to locus standi, although it makes sense to discuss it here for the sake of your mind map. Even though a spouse does not have written consent in terms of Section 17, he will still possess locus standi. In other words, he does not lose his locus standi to commence legal proceedings because he has failed to obtain written consent from his spouse in terms of Section 17. A defendant in an action brought by a spouse who does not have written consent cannot challenge the validity of the proceedings because of the lack of consent. In other words, the defendant cannot raise a special plea, dealt with later in this book under Actions, alleging a lack of locus standi. Lack of consent, however, carry negative consequences. If a spouse fails to obtain consent in terms of Section 17 and loses the case, the court may order him to pay those costs out of his separate estate, for example, money left to him by a deceased parent which falls out of the joint estate, or order that the cost be paid out of the joint estate, but that an adjustment be made to compensate the other spouse on division of the joint estate, for example, on divorce. 3.3. Mentally disabled persons. A person who is mentally ill and cannot appreciate the nature of legal proceedings because of some mental disorder does not possess locus standi. High Court Rule 57 provides a procedure whereby a person may be declared to be of unsound mind, and as such incapable of managing his own affairs. The ultimate purpose behind such a declaration is to allow a curator bonus or curator ad personam to be appointed to manage that person's affairs. Before that is done, however, the rule requires that a curator ad litem, that is, a curator appointed for the purpose of legal proceedings, is appointed to represent the person's interests. In other words, the appointment of a curator ad litem is usually precedes the appointment of a curator bonus or curator ad personam. The application for the appointment of a curator ad litem is typically brought by a family member or close friend who has the patient's well-being at heart. The applicant must establish his locus standi to bring the application and must provide sufficient evidence that the patient is of unsound mind and incapable of managing his affairs. Affidavits of 2 medical professionals are required in support of the application. In the application, the name of a person will be put forward as a suggestion for appointment as the curator ad litem, usually an advocate, and a consent letter from the suggested person will be attached to the application. The powers of the curator ad litem are set out in the court order appointing him or her. These powers typically include the power to investigate and report on the nature and extent of the patient's mental illness, the patient's assets and liability, and any other affairs of the patient. This information will be prepared by the curator ad litem in a report which will be placed before the court and relied on in any subsequent application for the appointment of a curator bonus and or curator ad personam. The appointment of a curator ad litem is frequently required for road accident fund claims, where claimants have suffered mental impairment and as a result of the road accident. Most divisions of the High Court have their own practice rules regarding the appointment of curators ad litem, which should be consulted before bringing an application in terms of Rule 57. In practice, if you suspect that a client whom you have been instructed to defend in a civil matter is mentally unwell, the first thing to do is to find out whether or not that person has been declared to be of unsound mind by the High Court. If not, consider whether the size of the estate of the person justifies the costs of a curator. If the estimated property value of the patient is under 200,000 and his annual income is below 24,000, it may be better to proceed in terms of the Mental Health Care Act, which provides a cheaper and simpler mechanism for the management of the mentally impaired person's affairs. If the size of the estate does justify it, you should find out whether or not a curator has been appointed to manage your client's affairs, and if a curator was appointed, whether or not such curator was granted the power to institute or defend legal proceedings on behalf of your client. If no curator was appointed, or if a curator was appointed but not granted the power to institute or defend legal proceedings on behalf of your client, an application to the court will have to be made for such appointment, or for the necessary powers to be granted to such curator. 3.4. Prodigals. In general terms, a prodigal is a spendthrift who is unable to keep his finances in order. The High Court may be approached to declare a person to be a prodigal, and as such incapable of managing his affairs. The appointment of a curator ad litem is not necessary, unless there is reason to believe that the prodigal does not understand the nature and effect of the proceedings. The order of the court will specify in what respects the legal capacity of the prodigal is limited, and he will retain his legal capacity in those areas not covered by the order. All litigation relating to those areas to which the court order applies must be conducted through the prodigal's curator bonus, if one has been appointed, or through a curator ad litem, specially appointed for the purpose of the litigation. A prodigal may litigate unassisted unless the court order which declared him a prodigal specifies that he may not do so. 3.5. Insolvence. Once a person has been declared insolvent and his estate sequestrated by the court, the person's estate is placed in the hands of the Master of the High Court, and a trustee will be elected to administer his estate. Although the locus standi of the insolvent is curtailed, he may sue or be sued in his own name, without reference to the trustee of his estate, in a range of circumstances which are set out in Section 23 of the Insolvency Act. Such matters include, for example, matters relating to the status of the insolvent. You would be well advised to consult Section 23 of the Insolvency Act carefully before dealing with any matter in which an insolvent is involved. Note further that the range of circumstances set out in Section 23 of the Insolvency Act is not exhaustive of all the situations in which the locus standi of an insolvent will be recognized. Generally speaking, in matters relating to the insolvent's estate, the trustee is the representative of the estate and it is the trustee who must sue or be sued in any matter relating to the estate. Be careful, however, not to sue a trustee in his personal capacity. He should always be cited in his representative capacity as trustee. In cases where one of the parties to litigation is declared insolvent during the litigation process, the litigation should be stayed until a trustee has been appointed. The trustee in his representative capacity should then be substituted for the insolvent as a party to the litigation. Note that civil proceedings against an insolvent will lapse 3 weeks after the first meeting of creditors unless the plaintiff gives notice in terms of Section 75 of the Insolvency Act of his intention to continue with proceedings. Bear this in mind if you have instituted proceedings against a person who is thereafter sequestrated. Note that the law relating to insolvency is complex and detailed. In a book of this kind, it is not possible to summarize this area of law adequately. You will be well advised, therefore, to consult the relevant legislation, case law, and specialist texts before dealing with matters involving insolvent and insolvent estates. 3.6. Fugitives from justice. The general approach of our courts has been that fugitives from justice have no locus standi. A fugitive from justice may not institute proceedings in the courts of this country, but is entitled to defend proceedings brought against him or her. If default judgment has been taken against a fugitive from justice, he is entitled to apply for rescission of that judgment so that he may defend the action against him. A fugitive from justice may not enforce a judgment in his favor by means of a writ of execution. Note, however, that despite the general approach of our courts, there is authority that it will not follow, as a matter of course, that the doors of the court will be closed to a fugitive from justice. Rather, the courts will deal with each case on its own facts. Closing the doors of the court to a litigant is a serious step, particularly in the light of the right of a party to have access to the courts. There must be a balancing of rights in light of competing policy considerations. 3.7 Alien Enemies. While a war is in progress, persons who voluntarily reside or carry on business in enemy territory, including South African citizens, may not sue in South African courts. They can, however, be sued in South African courts and will then be allowed to defend the matter. If, during a war, an enemy national is living in South Africa under state protection, that person has the right to sue in South African courts. In other words, the test for locus standi is not dependent on your nationality, but rather on where you reside or carry on business. If you voluntarily reside or carry on business in enemy territory, you are regarded as an alien enemy, regardless of your nationality. 3.8 Diplomats and the like. The Diplomatic Immunities and Privileges Act confers certain immunities and privileges upon the following general categories of persons and bodies. First, diplomatic missions and consular posts, and the members of such missions and posts. Secondly, heads of state, special envoys, and certain representatives. Third, the United Nations, certain specialized agencies as defined in the Act, certain other international organizations and their officials in the Republic. And fourth, officials and experts of the United Nations, of any specialized agency and of any organization and representatives of any state participating in an international conference or meeting convened in the Republic. The Minister of International Relations and Cooperation is obliged to keep a register of all persons entitled to immunities or privileges, and must ensure that a complete list of all persons on the register is published on the website of the Department of International Relations and Cooperation, and must cause the list to be updated as frequently as may be necessary, and made publicly available. If you have reason to suspect that a party in a matter in which you are involved may be entitled to immunity of some kind, you will first need to confirm your suspicions and then determine the precise nature and extent of the immunity enjoyed by the party concerned. You would be well advised to consult the relevant sections of the Diplomatic Immunities and Privileges Act, as well as the most recent list of persons entitled to immunity published on the website of the Department of International Relations and Cooperation. 3.9 Judges. In the unlikely event that you want to institute civil legal proceedings against a judge or serve a subpoena on a judge in connection with civil legal proceedings, whether it be one of the judges of the Constitutional Court, Supreme Court of Appeal, or the High Court, you will first need consent to do so. Section 47, Subsection 1 of the Superior Courts Act provides that no civil proceedings by way of summons or notice of motion may be instituted against any judge of a superior court, and no subpoena in respect of civil proceedings may be served on any judge of a superior court except with consent. This section is aimed at ensuring the independence of the judiciary by protecting judges against improper and spurious interruptions of their judicial functions. It seeks to protect judges from non-meritorious civil actions. Section 47 of the Superior Courts Act applies to civil proceedings instituted by way of action or application, that is, summons or notice of motion, and civil suits against judges for damages caused both in their judicial or non-judicial capacity. You will need the consent of the head of the particular court or division concerned. Where the matter concerns a judge of the Constitutional Court, the consent of the Chief Justice is required. Where the matter concerns a judge of the Supreme Court of Appeal, the consent of the President of the Supreme Court of Appeal is required. Where the matter concerns a judge of any of the divisions of the High Court, the consent of the Judge President of the division concerned is required. Finally, with regard to courts that have a status similar to the High Court, such as the Labour Court, the consent of the most senior judge of the court is required. In the case of civil proceedings against any of the above-mentioned heads of court, other than the Chief Justice, the consent of the Chief Justice must be obtained. In the case of proceedings against the Chief Justice, the consent of the President of the Supreme Court of Appeal must be obtained. Where consent is obtained, the date upon which the judge in question is required to attend court must be determined in consultation with the relevant head of the court. Under the Old Supreme Court Act, if the summons or subpoena was to be issued out of an inferior court, that is, a magistrate's court, consent was required from the division which has jurisdiction to hear an appeal in a civil action from that inferior court. However, these provisions of the Supreme Court Act have been repealed by the Superior Courts Act, which does not contain an equivalent provision. It would therefore seem that consent is no longer required, provided the summons or subpoena is emanating from an inferior court. In practice, the way in which you obtain consent is to make an informal application to the senior judge of the relevant court or division, giving notice of the application to the judge who is to be summoned or subpoenaed. Once consent has been obtained, the date on which the judge concerned is obliged to attend court must be determined in consultation with the judge president of the division of the court to which the judge who is being summoned or subpoenaed belongs to. In the unlikely event that you need to take civil action against a judge, you are advised to check carefully the state of the litigation pertaining to this matter. 3.10 Members of Parliament, Provincial Legislatures and Municipal Councils. When contemplating civil or criminal proceedings against any of the above, be careful, since special rules apply. In terms of Section 58 of the Constitution, members of the Cabinet, deputy ministers, and members of the National Assembly are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything they have said in, produced before, or submitted to Parliament or any of its committees. Furthermore, if what they have said, produced, or submitted leads to a revelation of some sort, they are still protected from liability. In terms of Subsection 71 and 117 of the Constitution, this protection is also extended to delegates of the National Council of Provinces and to members of the provincial legislatures. You should also take note of the provisions of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act. For example, special permission needs to be obtained before a summons, subpoena, or other process issued by a court is served within the precincts of Parliament. Further, take note that if a member of Parliament or a delegate to the National Council of Provinces is attending to business in Parliament and has a certificate issued by the Speaker of the National Assembly or the Chairperson of the National Council of Provinces in terms of Section 9 of the Act, it will not be possible for you to get that person to attend court as a witness in any civil or criminal proceedings, or as a defendant in any civil proceedings, until that business has been concluded. As far as municipal councillors are concerned, councillors are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything they've said in, produced before, or submitted to the council or any of its committees. Furthermore, if what they have said, produced, or submitted leads to a revelation of some sort, they will still be protected from liability. 3.11 Trusts. Trusts are strange legal entities and are difficult to compare to other legal entities, such as companies or closed corporations. Because of their strange nature, they are usually referred to as sui generis, in other words, something different and unique. A trust does not have a legal persona like a company or closed corporation. Trusts have become increasingly popular. Many family trusts are formed in an effort to reduce liability for estate duty. A trust is a legal institution in which a group of persons, known as trustees, holds and administers property separately from their own, on behalf of or for the benefit of someone else, or for the furtherance of a charitable or other purpose. The trustees of a trust, in their capacity as such, have no beneficial interests in the property of the trust. However, the assets and liabilities in a trust vest in the trustees. In other words, the trustees own the trust property for purposes of administration of the trust. It is the trustees who must either sue or be sued, since the trust itself cannot be either a plaintiff or defendant. Unless one or more of the trustees are authorized by the others, you must sue all the trustees in their official capacities as trustees. When trustees are acting in their official capacities, they are said to be acting nomen officio, and the letters NNO will appear after their names, or the letters NO if there is only one trustee. When a person is suing or being sued in his official capacity as a trustee, the words "in his capacity as a trustee of the XYZ Trust" or "trustee for the time being of the XYZ Trust" should be added after that person's name. 3.12 Partnerships, firms, associations, and the like. 3.12.1 The General Overview. Very often in practice you will find yourself dealing with a partnership, a firm, or an association of some kind. In most cases, these bodies have no legal personality of their own, but are simply groups of individuals who associate with each other in order to achieve certain lawful objectives. They do not exist apart from or in extension to the individuals who make up the group, and because of this do not possess locus standi. At common law, for example, a partnership cannot sue or be sued in its own name. Common law requires every individual member of a partnership to be joined and cited by name in any action involving the partnership, failing which the summons is bad for misjoinder. As is clear from the following quotation, the life of an attorney who decides to stick to common law when suing a partnership may become rather complicated. Where it is desired to sue a partnership and the names of the partners are not known, the plaintiff must ordinarily take steps to discover these names before he causes summons to be issued. He can try to discover the names by applying to any known member of the partnership to disclose them, but if the information is refused, he is obliged to apply to court after notice to such member for an order compelling him to disclose them, and ordinarily a plaintiff in the magistrate's court would have to move the High Court for relief. Fortunately, both the High Court and Magistrates' Court's rules make special provision for such cases, but these provisions are not without complications of their own. In general terms, these special rules provide procedural relief by allowing bodies such as partnerships, firms, and associations to sue or be sued in their own name, without in any way conferring legal personality on such bodies. Referring to the rule applicable in the Magistrates' Court's Rule 54, Harms summed up the effect of the rule as follows. The rule deals with procedure and not with substantive law. It does not turn a partnership or firm into a different entity or into a juristic person, existing separately from its members or owner. It does not create rights or liabilities which otherwise would not have existed. Let us examine the nature and effect of the rules applicable in the High Court and Magistrates' Courts respectively. 3.12.2 High Court Rule 14. High Court Rule 14 begins by defining inter alia an association and a firm as follows. An association is defined as any unincorporated body of persons not being a partnership. You may think of an association as a group of people who get together for a certain purpose, without forming themselves into a partnership or incorporating themselves into a company or close corporation. For example, your local hockey club or soccer club may be an association. And then a firm is defined as a business, including a business carried on by a body corporate, carried on by the sole proprietor thereof under a name other than his own. You may think of a firm as a one-man business, which is carried on under a trading name. For example, if you start a shoemaking business and call it Leo's Shoes, then that business may be defined as a firm in terms of Rule 14.1, Subsection 1. Remember that the sole proprietor does not have to be a natural person. The sole proprietor of a firm may be a company or closed corporation. In other words, if a company called ABC Proprietary Limited owns a shop called Leo's Shoes, then the business known as Leo's Shoes is a firm, even though it is owned by a company. High Court Rule 14 goes on to provide that a partnership, a firm, or an association may sue or be sued in its own name. This is quite a radical provision, since, as mentioned previously, at common law, only an entity which has legal personality may sue or be sued in its own name. In order to acquire legal personality at common law, an entity must possess a certain corporate character. An entity which possesses such a corporate character is referred to as a universitas personarum. The chief characteristics of which are, first, perpetual succession, that is, the association continues to exist, even though its members change. And secondly, the ability to acquire rights and incur obligations independently of its members, in particular, the ability to own property. In allowing a partnership, firm, or association to sue or be sued in its own name, Rule 14 clearly goes beyond common law. As we noticed earlier, however, the rule does not turn these entities into legal personae. When you sue a partnership, a firm, or an association, you are still, in effect, suing the individuals behind the partnership, firm, or association. The rule is simply an aid to procedure which allows you to sue these individuals in the name of the firm, partnership, or association. In terms of Rule 14, if you are suing a partnership or firm, you need not allege the names of the partners or proprietor. Even if you do, and you make a mistake with their names, this does not afford a defense to the partnership or firm. The rule allows the plaintiff to request the names and addresses of the person who was the proprietor of the firm, or the persons who were the partners of the firm at the time the plaintiff's cause of action arose. The firm or partnership is obliged to supply you with a list of the names and addresses requested, failing which you may compel the firm or partnership to do so. When the firm or partnership sends the list of its proprietor or partners to you, it must also serve a notice on the proprietor or the partners who it names in the list. This notice must accord with High Court Form 8. The notice basically warns the alleged proprietor or partner that if he disputes that he was the proprietor or a partner at the time of the plaintiff's cause of action arose, or that the period he is alleged to have been a partner is relevant to his liability as a partner, or that the firm or partnership is liable, he must enter the fray and put his case. If he fails to do this, and judgment is taken against the firm or partnership, he will not be entitled to dispute that he was the proprietor or partner at the relevant time. If you are successful in obtaining judgment against the partnership which you have sued in terms of this rule, you should bear in mind that the assets of the partnership must be excussed, in other words, taken in execution. First, in order to satisfy the judgment debt. It is only if the partnership does not possess sufficient assets to satisfy the judgment debt that the assets of the individual partners may be discussed. With regard to proceedings against firms, do not forget that you are in fact proceeding against the owner of the firm at the time your cause of action arose. If that person sells the firm to someone else, you cannot ask for judgment against the new owner or against the firm. You can only get judgment against the person who was the owner of the firm at the time your cause of action arose. As far as associations are concerned, Rule 14 provides inter alia that a plaintiff or defendant suing or being sued by an association may deliver a notice to the association calling for a true copy of its current constitution and a list of the names and addresses of the office bearers and their respective offices as at the date when the cause of action arose. The association must comply with this request within 10 days. If it does not do so, the party requesting the information may apply to the court for its delivery, or for the dismissal of the action, or the striking out of the defense. Where Rule 14, Subsection 2 is relied on by the plaintiff, for an example, an association sues on behalf of its members under Rule 14, Subsection 2, there must be a sufficient nexus between the individual members in their capacities as members of the association and the right that formed the subject matter of the litigation. 3.12.3 Magistrates Courts Rule 54. Magistrates Courts Rule 54 is the equivalent of the High Court Rule 14, but there are significant differences between the two rules. In terms of Rule 54, persons who are partners in a partnership at the time of a particular cause of action arose may sue or be sued in the name of their partnership businesses, referred to as a firm in this rule. An individual person who is at present conducting business in a name other than his or her own may also sue or be sued in the name he is using to conduct the business. The provisions of Rule 54 are also applicable in the case of unincorporated companies, syndicates and associations, which are bodies with no legal personality of their own. If you are suing or being sued by such an entity, you are entitled to send a notice demanding that you be provided with the names and places of residence of the partners, who were partners when the cause of action arose, the present proprietor or members, as the case may be, of the entity. The statement of names and addresses must be provided within 10 days. The action then proceeds as if the persons listed in the statement had been named in the summons. Note that if the statement of names is not requested by and disclosed to the plaintiff may not execute against the property of the individual partners, proprietor, or members, unless, as discussed below, the plaintiff makes an application to court to declare such persons to be partners, a proprietor, or members. This area of law is fraught with practical difficulties. For example, the notice to disclose is directed at the firm, and as a result, if there is non-compliance with it, one must apply to court to compel compliance with the notice, failing which default judgment may be granted against the firm. The same problem then arises, however, in that the default judgment is against the firm, not the individual partners. Before proceeding, you will be well advised to consult the cases cited in this section, as well as a detailed reference work dealing with the procedure. Rule 54 divides a further mechanism for linking a suspected partner, proprietor, or member to the proceedings. The procedure involves an application to court to declare a person to be a partner, proprietor, or member of the entity suing or being sued. If the application is successful, the action proceeds as if the persons in respect of whom the application was brought had been named in the summons. This is a very useful procedure to bear in mind, since it may be invoked both before and after the judgment. This means that even if you have neglected to obtain the statement of names and addresses referred to earlier, which would have allowed you to execute against the personal assets of those listed, you are able to cure this omission even after judgment. Number 4. Representation of parties. 4.1 Power of Attorney. Having discussed the issue of locus standi in relation to parties of various kinds, we turn now to a discussion of the different rules relating to the manner in which parties may be represented in court, starting with a brief look at power of attorney. A power of attorney is a written document which confers authority upon an agent to act for his principal. There are two kinds of power of attorney. The first kind is called a special power of attorney and authorizes the agent to act in a specific matter or matters. The second kind gives the agent a general authority to perform all acts on behalf of the principal, which the principal might normally perform himself. Usually, a general power of attorney is given to an attorney, a family member, or a trusted friend. When the principal plans to travel or is incapacitated in some manner and needs to have his financial affairs dealt with in his absence. In the context of civil procedure, a special power of attorney may be given to an attorney by his client, authorizing the attorney to initiate or defend a specific legal proceeding on his behalf, and to perform those functions that are incidental to such legal proceedings. The purpose of a power of attorney is to protect both attorney and client. On the one hand, it prevents a client who wishes to avoid paying an attorney's legitimate fees from denying that he gave the said attorney authority to act. On the other hand, it may serve to protect a client from an unscrupulous attorney who knowingly exceeds his authority in order to earn extra fees. Should an attorney conduct litigation without the authority of his client, he will not be entitled to recover his fees from the client, and may even be ordered to pay the costs of the proceedings personally. Usually, a special power of attorney giving authority to a firm of attorneys to institute or defend legal proceedings should include the following details. First, a general description of the nature of the particular action to be instituted or defended for which authorization is given. Secondly, the nature of the relief claimed or to be claimed. Third, the names of the parties to the matter. And fourth, the names of the attorneys, including both partners and professional assistants, authorized to act on the client's behalf. Note that when a juristic person such as a company, closed corporation, or local authority wishes to institute or defend legal proceedings, it is not sufficient for you to take instructions from a director, member, or official of the particular entity. You, as the attorney, must be officially instructed by the company, closed corporation, or local authority to institute or defend legal proceedings on behalf of the company, closed corporation, or local authority. Usually, in the case of a company or a closed corporation, you will request the board of directors of the company or the members of the closed corporation to pass a resolution authorizing you to institute or defend the legal proceedings. In the case of bodies such as local authorities, there are often standing resolutions which delegate the power to institute or defend legal actions to certain officials of that body. You may accept a written instruction to act from such official, together with the relevant extracts from the standing resolutions of the local authority concerned. All written instructions conferring authority upon you to act in such matters should be in the form of an affidavit by the official or office bearer concerned, together with a copy of the supporting documentation, for example, the relevant resolution of the juristic body concerned. 4.2 Representation of parties in the High Court. A natural person who becomes involved in legal proceedings in the High Court and who has locus standi is entitled to conduct his own case and to appear in person at the hearing. Alternatively, he may be represented by an attorney and advocate, or by an attorney alone if that attorney is entitled to appear in the High Court, whom he has instructed to represent him. He may not be represented by anyone else. As far as juristic persons, such as companies, are concerned, the general rule is that they must be represented by an advocate and an attorney, or by an attorney alone if that attorney is entitled to appear in the High Court, and may not be represented by one of their officials. This general rule is, however, not inflexible. For example, the High Court may, by making use of its inherent power, allow a sole member of a close corporation to represent it in court where it is in the interests of justice to do so. The legal representative of a party in the High Court need not, as a general rule, file a power of attorney in order to prove that he possesses the necessary authority to act. A power of attorney need only be filed in the case of an appeal. The authority of anyone acting on behalf of a party may be disputed at any time before judgment. This must be done within 10 days of the date on which the person disputing the authority learned that the person whose authority he is disputing was acting in the matter. If more than 10 days have passed, the leave of the court must be obtained on good cause shown. A person whose authority has been disputed may not act in the matter until he satisfied the court that he is authorized to act. One way in which he may satisfy the court that he is authorized to act is to produce a valid power of attorney. If you are an attorney and a client appoints you to act on his behalf, the first thing you must do is notify all the other parties involved that you are acting on your client's behalf in the matter, and provide your name and address. Your client may at any time terminate your authority to act. If he intends to deal with the matter further by himself, then he must notify the registrar of the court which is considering the matter and all the other parties by written notice. The written notice must include a service address, which is within 8 kilometers of the registrar's office, where the other parties are available to serve further documents in the matter upon him. If, instead of dealing with the matter further himself, he decides to appoint another attorney to continue acting on his behalf, he must notify the registrar and all the other parties by written notice of the name and the address of his new attorney. His new attorney's address will become his new service address. The attorney who is no longer acting must forthwith deliver a notice to his former client, the registrar, and all other parties, stating that he is no longer the attorney of record. In practice, this notice is known as a notice of withdrawal as attorney of record. After the notice of withdrawal as attorney of record has been sent out, the former client of that attorney has 10 days to send the notice referred to in the previous paragraph, informing the parties of his new address for service. If he does not do this, then the other parties may well not have an address upon which to effect service of documents upon him. In such a situation, the other parties need not serve any further documents upon him, unless the court orders otherwise. So the lesson is that parties must be careful if they decide to fire their attorneys. Also, attorneys may not simply withdraw from a case at the last minute. They have a duty towards both their client and the court to withdraw in good time. 4.3. Representation of parties in the magistrates' courts. In terms of Magistrates' Courts Rule 52, Subsection 1a, a party may institute or defend and may carry to completion any legal proceedings either in person or by a practitioner. The term practitioner includes an advocate, an attorney, and a candidate attorney. Attorneys are clearly entitled to fully represent parties in the magistrates' courts. Advocates, however, are prohibited from doing the work of an attorney in the magistrates' courts by the Attorneys Act 53 of 1979. Advocates are not entitled to sign pleadings in magistrates' courts matters, nor any of the Magistrates Court's forms prescribed in Annexure 1 to the Magistrates Court's rules. The work of advocates in the Magistrates Courts is essentially restricted to the drafting of pleadings and applications and appearances in court. Before an advocate may perform work in the Magistrates Courts, he must be duly briefed by an attorney. As far as candidate attorneys are concerned, there is some debate as to their precise powers. It is clear that, subject to certain restrictions set out in Section 8, Subsection 1 of the Attorneys Act, a candidate attorney who has satisfied certain legal requirements is entitled to appear in court, other than any division of the High Court, and before any board, tribunal, or similar institutions, in or before which his principal is entitled to appear. A candidate attorney appears instead of and on behalf of his principal, who is entitled to charge fees for such appearances as if the principal himself had appeared. Whether or not a candidate attorney's powers go beyond this to enable him to carry to completion any legal proceeding is open to debate. In magistrates' courts, a local authority, company, or other incorporated body may act through one of its officers who has been nominated to act in the legal proceedings. A partnership or group of persons associated for a common purpose may act through one of its members who has been nominated to act for the partnership or group in the legal proceedings. No power of attorney need be filed by the person who is appointed to act, but the authority of that person to act may be challenged by any other party to the proceedings at any time before the judgment. The challenge to authority must be raised within 10 days of the date on which the person challenging the authority learned that the person whose authority he is challenging was acting in the matter. If more than 10 days have passed, the leave of the court must be obtained on good cause shown. A person whose authority has been disputed may not act in the matter until he satisfied the court that he is authorized so to act. One way in which he may satisfy the court that he is authorized to act is to produce a valid power of attorney. 4.4. Representation of indigent persons. 4.4.1. In forma pauperis proceedings in the High Court. If a person wants to bring or defend proceedings in the High Court but does not have sufficient money to do so, he may turn to the High Court Rule 40 for assistance. Rule 40 sets out the rules for what are called in forma pauperis proceedings. In other words, proceedings where one of the parties does not have enough money to pay for his case. In forma pauperis proceedings are not the only option available to a person who does not have enough money to institute or defend legal action. Legal aid is also available through other avenues, for example, the Legal Aid Board, the Legal Resources Center, the legal aid clinics at various universities, and so on. The growth of legal aid has made in forma pauperis proceedings much less common, but it is a procedure which is still used. In order to qualify for the provisions of Rule 40, a person may neither possess property which is worth more than 10,000 rand, nor be able to obtain that amount from his earnings within a reasonable time. Household goods, clothing, and tools of trade are not included in this calculation. The procedure that is adopted is that the person wanting to proceed in forma pauperis makes an application to the registrar. If the registrar is satisfied that the person qualifies, he will refer that person to an attorney, whose name appears on a roster in the registrar's office, and will at the same time inform the Society of Advocates. The attorney looks into the case and into the financial position of the applicant. If he is satisfied with the merits of the case and with the lack of means of the applicant, he will request the Society of Advocates to nominate an advocate to act with him in forma pauperis in the matter. The obligation in this regard rests on the attorney to inquire into the merits and, only if satisfied of the merits, to request an advocate to be nominated. The Society of Advocates is not required to appoint an advocate if the attorney recommends that the prospects of the matter are poor. 3 documents then have to be drafted. First, when the proceedings are instituted, an affidavit must be lodged with the registrar on behalf of the person who is proceeding in forma pauperis. The affidavit must set out that person's financial position and state that, except for household goods, wearing apparel, and tools of trade, that person does not possess property worth more than 10,000 rand. Secondly, the advocate and the attorney must also lodge a statement to the effect that they are acting gratuitously in the matter. And lastly, the advocate must lodge a certificate probalis causa, in other words, a certificate stating that the person has a fair or reasonable hope of success. The matter then goes ahead as normal, except that all pleadings, processes, and documents filed of record by the party proceeding in forma pauperis must be headed accordingly. The only ray of light for the legal practitioners who are doing all this work for no monetary reward is that upon the conclusion of the proceedings, the litigant in forma pauperis may be awarded costs. This means his attorney may include in his bill of costs such fees and disbursements to which he would ordinarily have been entitled. Upon receipt thereof, in whole or in part, the attorney will pay out the sheriff's charges for the service and execution of process, and thereafter disburse himself and the advocate. These will be fees as allowed on taxation and may be paid pro rata if necessary. 4.4.2 Pro Deo proceedings in Magistrates' Court. The equivalent in forma pauperis proceedings in the Magistrates' Court is set out in Magistrates' Court Rule 53. A person who does not possess sufficient means to institute or defend legal proceedings in the Magistrates' Court may apply to court for leave to sue or defend as a pro deo litigant. Without going into the procedure in detail, we note simply that it is different to the in forma pauperis procedure followed in the High Court, and advise that you consult Magistrates' Court's Rule 53 should you wish to advise someone desiring to ensue or defend as a pro deo litigant in a magistrate's court.